neither a borrower nor a lender be. Such was the advice that the character Polonius gave his son Laertes in Shakespeare's Hamlet. If only the decision-makers at Connecticut's Citytrust Bank had listened to those words. Perhaps Citytrust could have avoided having one of its own shareholders attempt to sue the bank over some questionable financial decisions in the case of Joy versus North. For a 10-year period starting in 1967, Citytrust made loans and other business decisions related to an office building constructed and owned by an outside corporation. Those decisions ultimately resulted in Citytrust owning the building and the building's substantial mortgage. Citytrust faced a minimum $5 million loss on the transactions. In 1977, Dr. Athalie Joy filed a shareholder derivate suit in federal court against Citytrust that alleged common law claims and violations of the National Bank Act. Citytrust appointed a special litigation committee that assessed the derivative suit, determined that the suit was not in the best interest of the corporation, and recommended the suit be dismissed as to most of the defendants. Joy refused to dismiss her case, and Citytrust filed a motion to dismiss in district court. While the case was pending, the United States Supreme Court held in Burks v. Lasker that a federal court considering the propriety of dismissing a derivate suit based on the recommendation of a special litigation committee must apply state law even if federal claims are involved. The district court considered and ruled on two questions. First, whether Connecticut law recognized a special litigation committee's ability to seek dismissal of a shareholder's derivative suit. And second, whether the business judgment rule applied to the committee's recommendation. The business judgment rule is a common law doctrine that provides immunity to corporate directors for mistakes in business judgment. Because there was no dispositive Connecticut case law or statute, the district court predicted that under Connecticut law, a special litigation committee would be permitted to recommend dismissal of a derivative suit and that the business judgment rule would apply to that decision. Finding that the Citytrust Special Litigation Committee had acted independently, thoroughly, and in good faith, the district court granted summary judgment for the Citytrust defendants. Joy appealed to the United States Court of Appeals for the Second Circuit.